If I'm questioning a doctor during his deposition and I know that he lied, he just answered a question to which I know is a definite lie, do I turn to him and say, "Doctor, you're a liar. Doctor, you just told me something that wasn't true"? Do I do that? You want to know the answer? Come join me on this walk as I tell you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, I don't. I let that doctor's lie stand, which means I'm not going to correct him. I'm not going to call him out during this question and answer session, which takes place before trial. So here's the scenario. Let's say you brought a lawsuit against your doctor claiming that he was careless and caused you significant harm and injury. Your doctor denies any of those allegations. During the course of your lawsuit, I will have an opportunity to question your doctor, to learn from him exactly what he did and why. Why did you do certain things? What problems did the patient have? What were your options? What were the alternatives? I need to get into the doctor's mindset to understand exactly what he did and why. Now, in pre-COVID times, this was done in the defense attorney's office in their conference room. The doctor would be there, the doctor's attorney would be there, any other attorneys who were part of this case would be there, and there would also be a court stenographer, a court reporter there to record all of my questions and all of the doctor's answers. Now, you should know there's no judge there, there's no jury there. In COVID times, instead of doing this in the attorney's office, now we do it on a Zoom video call. And you might be thinking, okay, those aren't recorded. How do you record that information? The same way we do it when we're in person. There will be a court stenographer on the call to record all of my questions and all of the doctor's answers. And in case you don't know, the doctor's answers represent sworn testimony and carry the same exact weight as if he is testifying at the time of trial in court, in front of a judge, in front of a jury. So as I'm questioning the doctor, I will have lots of questions to ask him. I want to establish what was the standard of care for a patient who comes in with the problems that you had. I want to hear in his own words exactly what his understanding of the medicine was. Did the doctor have a good understanding of what should be done in this circumstance? And then I will begin to ask him questions not only just about the standard of care, but I want to know exactly what he did and why. And ultimately, I'll ask him about his medical records and exactly what problems you had, what you complained of, what he did, what his examination consisted of, what his findings were, what his course of treatment and course of plan of action was. I will ask him all of those things. But now let's say I ask him a question to which he outright lies. I know for a fact, based upon my research, based upon the records, that the doctor's answer should be different. And it's not a question of, oh, I remember that this happened, or I remember the patient told me this, so I gave her this medication. I'm not talking about something like that where the doctor, after many years, doesn't remember exactly what happened, because that's understandable. That's often why doctors will write notes and write a detailed record that's accurate and thorough and detailed, so that at any time later on, he or another doctor or another healthcare provider can look back and see exactly what was done and what took place during a particular visit. So I'm not talking about something where the doctor has a poor memory or a poor recollection of a particular instance, of a particular visit. I'm talking where the doctor outright lies. Doctor, you went ahead and did this procedure because this patient had the following things, isn't that right? Yes. And you did that because you knew that this patient could suffer the following problems, isn't that right? Yes. Now, did you have a discussion with the patient about the risks associated with this particular procedure? Yes, I did. Now, I know, according to my client, that the doctor had no discussion whatsoever with the patient, none about the risks. And I know that because she has told me that, and I also know that because the defense lawyer has questioned her at her own deposition. Her own deposition, where she was questioned by the defense attorney. And she was asked that question. Did the doctor have a conversation with you about the risks of this procedure before you agreed to it? No, he did not. Who else was with you in the office? Oh, 3 people were with me in the office. My daughter, my sister, and my husband. Okay, and now, do they have a memory of that particular visit? Yes, they do. And do each of them recall that the doctor had no discussion with you whatsoever about the risks? That is absolutely correct. So now, here we have 4 people, who have testified that they have a definite, specific memory that the doctor had no discussion with them whatsoever about the risks of the surgery. And now the doctor turns around and says, of course I had a discussion with them. Doctor, do you remember having that discussion? Well, I don't remember exactly. It's been so many years. I've seen so many patients. But that's what I always do. Wait a second, doctor. Let's step back. I'm asking you whether you, right now, as we sit here today, on this Zoom video deposition, do you have a specific memory of talking to Mrs. Jones about the risks of this procedure? Well, I don't have a specific memory, but, doctor, I'm not asking you but. It's either yes or no. Did you? Yes, of course I did. Doctor, I understand you've told me that your custom and practice is to discuss with the patient the various risks, the benefits, and alternatives to any surgery, correct? Yes. And you normally do that because that's good medical practice. Isn't that true? Yes. And the reason it's good medical practice is because the patient needs to understand and be educated about the various risks for the procedure, correct? Yes. And in order to make an educated decision about whether she should have this procedure, she needs to understand what the risks are, correct? Yes. And she also needs to understand what the benefits are of this particular procedure that you are recommending, correct? Yes. And she also needs to know exactly what the alternatives are, correct? Yes. And you would agree, doctor, that if a physician failed to tell a patient about the risks of a procedure, that would be a departure from the standard of care, wouldn't it? Well, I don't know if it would be a... Doctor, I'm just asking you whether or not it's important to tell the patient about the risks of a surgical procedure that you recommend. Yes, it would. So I'm simply turning that question around now, doctor. If a physician fails to tell the patient about the risks, that would be a deviation or a departure from the standard of care, right? The doctor has to agree. Let's go back to the question I raised in the title of this video. The doctor turns around and says, I, of course, told this patient about the risks of this procedure. Do I go ahead and call him out and say, doctor, you're a liar. My client testified just the opposite. You know what I do? I move right on. Why? Because the doctor has now locked himself into that testimony. The doctor has now established a glaring contradiction between his testimony and my client's testimony, and about all the other people who were in that office visit with my client, who now all confirm that this doctor had no discussion whatsoever with this particular patient. And it's also important that the doctor doesn't have a specific memory. So now I could get into an argument with him, and you're also aware that she told your attorney that you did not have any conversation with her whatsoever about the risks of this procedure. You're aware of that, right? Yes. Now, it would be kind of silly for me to say, well, what do you have to say about that? No, no, no. I don't want to confront the doctor about this contradiction yet. Why not? Because the best time to do this, the best time to use that contradiction against the doctor would be at the time of trial, in front of a jury, in front of the judge, to establish that this doctor has lied. And you begin to wonder, if this doctor has lied about one thing, what does that mean about his other testimony? Is it possible that he's lied about other things involving this patient's care and treatment? That is a possibility. So there are different strategies for dealing with inconsistencies and with lies during the course of a deposition. In this particular scenario, it would be in our best interest, in my opinion, not to attack the doctor and address it head on, but rather to simply move on, because now I've established the contradiction, and at trial we can show to the jury exactly how important that contradiction is. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I realize you're likely watching this video because you have questions or concerns, or just want to hear the birds chirping. No, I realize you likely have questions or concerns about your own matter. Well, if you are thinking about bringing a lawsuit and have not done so yet, and your matter happened in New York, and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.